So thank you very much to Professor Heinz Goddard. Thank you very much to the organisers of this conference for inviting us here. I'll try and be very brief. The European Patent Office has been already involved in a special kind of unique approach to the way that we deal with standard essential patents over the last 15 years. And primarily we work with ETSI, which is the European Telecommunications Standards Institute, but they're also responsible for 3GPP and obviously 4G, 5G and so on. And that's our kind of what we consider to be the best case collaboration between a standards development organization and a patent office. And we're trying to kind of promote and extend this cooperation to other standards organizations and potentially to other patent offices as well. The primary job of a patent office is to deliver, where they are appropriate, temporary exclusive patent rights, where a patent application is filed with us and the subject matter is really new and inventive and industrially applicable, as they say. And that is effectively patent quality. The claims should be well defined and the scope of protection should be well defined, and we must do our utmost to show that this is in fact new and inventive. So what we do in particular is our cooperation with the standards development organizations tends to revolve around agreements, memorandums of understanding that we form with the standards organizations. And there are several purposes of the memorandums. Firstly, it allows us to define with the standards organization, we agree that any technical disclosures which are made at those standards organizations when they build the standards and they decide what are the standards for interoperability, that documentation is not secret, that it is submitted in good faith, mostly to their competitors that are also around the table, and that is therefore just as much a disclosure as if a professor or somebody else were to disclose something at a meeting like this where many public people and their competitors may well be there. So we have a bit of a grey zone as to whether the technical documentation submitted to standards organizations is prior art or is not, but under European law, if it's not under a non-disclosure agreement, then it is prior art. Secondly, the MOUs allow us to collate the documentation and put it in our internal databases, which makes it very easy for us to search it, and our examiners can find the documentation very quickly, very effectively, and can cite it as prior art. So now we have 3.2 million standards documents in our databases, largely from the 3GPP process, but also from ETSI itself, from IEC, from IEEE, and we are constantly expanding this collection as standards and standard essential patents become more important in further ICT areas. Rudy Beckers and his academic team in Amsterdam did a study on the effect of this, and they conservatively came up with the idea that we grant about 12% less patents as a result of this policy. So we have what we would call independent evidence to prove that this is actually valuable. This is simply a graph of the documentation that we have incorporated into our internal databases. You can see that in 2007 there was very little there, and over a 10-year period we've expanded to over 3 million documents, and that is rising all the time. These are the number of documents that we've actually cited against patent applications as prior art. It's also rising throughout this period. It's now at about 22,000 a year. That's not that many compared with the 1 million citations that we actually cite per year, but in key particular technical areas, you'll find a standards document on 60% of the search reports in the telecom area, in Wi-Fi. So in those technical areas, it is very significant indeed. And as you can see, it is rising all the time. There was another 12% increase from 2016 to 2017, and that increase is simply continuing. We've also seen quite a surge in the number of standard essential patents that have been declared at ETSI last year, and we now see a real surge coming in from 5G, and so that's MPEG, JPEG, and so on. We're under discussions with them, and we're just completing an MOU also with Sensenelec, which are the other two European standardization organizations. So they mirror ISO and IEC at the European level, and we're just concluding an MOU with them as well. So the policy is continuing. The other job is to increase the transparency about standard essential patents. And the standard essential patents that are declared, they are the basis for licensing, but you also need transparency about how widely they're patented, whether they're still legally valid or not. One thing I would emphasize here is that this is a very, very complex process. So basically, you have ongoing fundamental research at major companies like Ericsson, Nokia, Qualcomm, and so on all the time. And the engineers, once they've developed one product, they already know which direction they would like to go in to further improve things with the new technical capabilities. At the same time, they're coming together at the standards bodies to produce the next generation, which could be 5 years, 8 years apart, for the telecommunications industry. So they propose technical solutions all the time, agree what those technical solutions should be for 3G, 4G, 5G. Meanwhile, license negotiations are going on all the time between these companies, between their different portfolios, as to who has which share of the 3G, 4G, 5G standard essential patents. And the implementers all the time are also forming freedom to operate license negotiations with these companies. Furthermore, the patent prosecution that takes place is also very important. You'll see from the DG GROW report that standard essential patents are filed on average in 28 jurisdictions. So the legal protection, the scope of the legal protection, the geographical scope is very wide indeed for standard essential patents. They're nearly all PCTs. That also means that the patent prosecution process is 5, 6, 7, 8 years, is also a long time. Therefore, it's not a simple case of one or two standard essential patents and one or two license negotiations on them and whether they really are standard essential or not. You have something like 20 companies with over 1,000 SEPs, so they're big portfolios, a lot of them, and all of these processes, these 4 parallel processes that are going on all the time, take several years each, and there's a constant portfolio with many of these companies of granted patents, pending patents, patents that have been filed that haven't even been published yet, etc. So it's not easy to get transparency in this area, and you're talking about big portfolios and the contributions of each of those big portfolios often. Now, I've got a little bit lost here because I'm not quite sure. Let's just shorten it slightly. The European Commission is very, very interested in the whole standard essential patent scenario in Europe being as clear as possible, because in their digital single market initiative, they want clarity and they want Europe to be a good place for development of the Internet of Things and the technologies that are dependent on the Internet of Things. Therefore, they're trying to form a well-balanced, basically landscape in which SEPs can be developed, in which these technologies can be developed, people can get a good return on investment, but nevertheless the people that need to use these for the Internet of Things in the many different areas, big players and small players, can get good license arrangements. And it's that balance that's always important, which is the basis of the whole patent system. So they've carried out studies on standard essential patents. They've come out with their paper on the European approach to standard essential patents to try and define what they consider to be a balanced environment. And now they're starting a major pilot on standard essentiality, basically essentiality checks on standard essential patents. And they're looking to see which players could help them in improving the clarity as to, which ones really are standard essential patents at the end of the day. And there's the question of whether patent offices should share that role or play a part in that role, and that's something that will be decided in this pilot maybe over the next year. One thing that we are aware of is, Heinz, as you mentioned, the Japan Patent Office is already providing effectively essentiality checks on standard essential patents. We would appreciate if there was a kind of an IP5 wide view on this. So we have the IP5 cooperation with Japan, China, Korea, the United States and Europe. We would prefer to have a more universal approach to this. We'll also be interested in talking to the Indian Patent Office and other patent offices about this to try and get a kind of a common approach, because we don't think it's a unilateral approach. The whole 3G, 4G, 5G Internet of Things is a global scenario. And as I said, most of these patents are filed in, like, on average, 28 jurisdictions. Therefore, it really should be a global approach and not a unilateral approach. So we'd appreciate an IP5 view to this, and we've put it on the agenda of the IP5 discussions, but we've not made a lot of progress with that yet. We hope it will continue. One thing that's also important is that standard essential patents that are declared at ETSI, you can basically click on those. They link into our ESPASnet, which has 100 million patent documents in it. So you can go from the declared standard essential patent number, you can click on that, you go straight to ESPASnet, and then you can see the patent family, you can see the documents that are filed for each patent family member around the world. You can also look at the legal status data that we have from 57 jurisdictions. It is, by the way, very important to get the Indian patent data implemented in this as well, so that you can go from the databases of standard essential patents to also see which ones are filed in India. So that's something where we're progressing with discussions with the Indian Patent Office as well. But this is an important part of transparency as well, and we wish to work with the other patent offices, with the standards organizations, to see if we can improve this transparency further. So firstly, the patent offices have to maximize the patent quality, and secondly, we have a role in maximizing the transparency. So before you ever start license negotiations, you need to know which patents you should be dealing with. Thank you.
Yeah, thank you so much, Jen. I appreciate very much that we know already now the